Good morning, good afternoon. Thank you so much for joining us for today's roundtable, Exploring Clean Slate Legislation Perspectives from Different States. I am Laura Chavez, the Director of Research and Data for the Clean Slate Initiative, and I will be moderating our discussion today. We are incredibly fortunate to have with us a group of leading researchers, Derek Veitenheimer from Search, Kristin Bechtel from RTI International, Alissa Skog from the California Policy Lab at UC Berkeley, and KiDeuk Kim from the Urban Institute. Each of our panelists bring deep expertise and insights into how clean slate automatic record relief laws are unfolding in the states where they are respectively researching. And they all have great insights about what we can learn from variations in policy design and implementation across states. Before we jump into the panel, I'd like to take just a few minutes to frame our discussion with some important context and definitions. First and foremost, criminal records, whether conviction, dismissed case, or even just an arrest that didn't lead to charges, can have long-standing and deeply harmful effects. They prevent individuals from even getting their foot in the door for interviews, getting high-quality jobs, housing, education, professional licensing, the list goes on. Criminal records limit access to public benefits and can impact parenting rights and immigration outcomes. And these barriers, of course, don't just affect individuals, but they impact families, communities, can entrench cycles of poverty and racial inequality. So what is record relief? When we talk about record relief, we're referring to the legal mechanisms that limit the visibility of a criminal record. Typically, there's two mechanisms: expungement, which deletes or erases the record completely, or sealing, which hides the record from public view. Interestingly, some states use these laws, these terms interchangeably in their laws, and some other states use different terms like set aside or erasure. But in general, those are the mechanisms of relief. Relief can be granted by petition, where someone has to take action and often hire a lawyer or consult someone in the legal field, pay a fee, go through a court process, or it can happen automatically where the state initiates the process based on certain eligibility criteria. Petition-based relief has extremely low take-up rates. J.J. Prescott and Sonia Starr, their work published in the Harvard Law Review, and Colleen Chen's work on the second chance gap have found that fewer than 10% of people who are eligible for relief ever complete that petition-based process. But today we're discussing clean slate legislation. Clean Slate is a policy model that aims to automate record relief for people who meet the eligibility criteria. Those criteria include the types of records eligible for relief, misdemeanors, felonies, types of offenses, etc., the number of records eligible. For example, there could be a cap on the number of misdemeanors or felonies on a person's record that are eligible for relief, and the waiting period or time between the case disposition or a person's sentence completion and their eligibility for relief. During that waiting period, the eligibility criteria typically lay out that a person must not have had any subsequent arrests or convictions. At the Clean Slate Initiative, we define clean slate policies as those that apply automatically upon eligibility of the record without the need for an individual petition, noting that the eligibility criteria varies from state to state. And we also say that clean slate policies have to include non-conviction and at least some misdemeanor conviction records among those eligible. We also strongly recommend that ideally at least one type of felony record is included in a clean slate law as well. For a little bit of background about our organization, the Clean Slate Initiative is a national nonprofit dedicated to passing and implementing clean slate laws at the state and federal levels. To date, since 2018, 12 states and the District of Columbia have passed clean slate legislation that meet our definition. We work in partnership with state advocates supporting implementation efforts, and we use research and data to strengthen our policy design. Our goal is to ensure that every person that's eligible receives relief automatically so that their records no longer limit their future opportunities. And we invest in research and data in no small part because we want to determine not just who has received relief and what the impacts are, but also who hasn't, why not, and what we can do to close those gaps. And in doing so, improve our policies and thus expand their impacts. Passing clean slate legislation and ensuring that people can access relief automatically is really a necessary first step. People can't get their foot in the door for so many opportunities to better their lives in employment, housing, education, etc., as long as they have a record that shows up on background checks. So automatic record relief we see as a necessary, but not necessarily sufficient to ensure that people with records get good jobs that pay a livable wage and otherwise support long-term economic mobility and stability. One important challenge with automatic relief is that people need a mechanism to become aware that their eligible records have been sealed. Otherwise, they'll self-disclose even if the record is concealed from view for employers or landlords. And we are now facing increasing competitiveness in job markets in this moment where the political climate has changed and there's a great deal of uncertainty, especially economic uncertainty. In addition, federal funding is being rolled back, and we need to acknowledge that although clean slate policies have bipartisan support, the people who stand to benefit from record relief are still facing barriers. So today our panelists are going to get into how different states are tackling and looking at clean slate implementation, from early adopters like Pennsylvania and Utah to newer clean slate states like California. The panel is going to help us understand the scope of the laws, who's benefiting, the challenges that remain, and where we need more research. I will be monitoring the chat for questions as our panelists are speaking, and as long as that's manageable, we can stop for questions as we go. If there are a ton of questions, I might ask that we save those until the end. So with that, let's dive right in. The first question for the panelists, can you each introduce yourselves, the organization you're with, and briefly summarize the work that you're doing related to clean slate policies? And feel free to go in any order.
Thank you, Laura. My name's Kristin Bechtel. I'm a principal scientist at RTI International, and the team I have the privilege of working with at RTI. Um, our focus is right now on the state of Pennsylvania, and in particular, while our project started out as a national scan of where there might be policies where evaluation could be possible, and we did produce a forthcoming publication about this and automated record sealing policies. The current evaluation includes two steps. The first step looks at being able to locate individuals who are eligible for record sealing, automated record sealing in the state of Pennsylvania as a result of their new legislation, which is Pennsylvania Clean Slate 3.0. And the second step is to be able to test notification. Since the state of Pennsylvania has this automated process, this does mean that notification isn't necessarily going out to individuals. So while they do have this legal remedy available to them, it's about looking deeper into whether or not notification really helps them leverage that legal remedy.
I can go next. My name's Alissa Skog, and I'm a researcher at the California Policy Lab at UC Berkeley. Unsurprisingly, we are focused on California, and I'll get into the details of the relief laws here in a bit, but we last year released a descriptive report just trying to understand who's benefited from automatic relief in California, what share of people that had records relieved had a clean slate as a result, and then trying to understand people who still have records remaining, what types of records those are, demographics, etc. And we are currently working on a causal study that's focused on the impact of receipt of a clean slate on future arrests and convictions.
I'm Derek Veitenheimer. I am the Executive Director of Search Our organization is a national nonprofit organization that is primarily made up of governor-appointed members from each of our 50 states and territories that generally reside in the criminal history repository side of things within the state's criminal justice system. Our work, generally speaking, we do a lot of information exchange, research, and data quality and data completeness improvement work related to the criminal history record. The backbone really of our organization is to really push and strive for improved criminal history records. And we work with our members and states in doing just that. Where that relates to Clean Slate, obviously specifically related to the criminal history repositories at the state level and working with them within this record sealing process to ensure that it functions, that it operates, and that it's accurate. The current project that we're working on right now, as it pertains to or relates to Clean Slate, is working with states that have passed legislation to do a deep dive into what their legislation is, how that impacts their state, and kind of the nuts and bolts to how their criminal justice system as it pertains to Clean Slate and record sealing operates. So doing state profiles that are aimed to educate and hopefully develop an understanding of how those Clean Slate and record sealing processes work within each individual state. In addition to that, we've started a community of practice, primarily made of the subject matter experts, the folks involved at the state level, whether they're from the courts, the criminal history repositories, or other areas of government, to build a community of expertise and record sealing, understanding the environment that these record sealing projects are involved in. What's working well? What isn't working well? Where are improvements needed? Where are the roadblocks within each state's criminal justice system? And there are many, as I'm sure you could imagine. So developing this community to share best practices, develop new models of best practices of how to implement and successfully manage and operate Clean Slate projects. And additionally, we are developing a series of policy guidance documents. We originally called these implementation playbooks, but we think policy guidance documents have a nicer ring to it. And what these are designed to do is to really target an audience, whether it be repositories, the courts, legislators, and provide information about the Clean Slate project, about record sealing, and again, leveraging what we've learned from states and promoting best practices so that these projects can be implemented and then successfully run. So excited to chat with all of you today.
My turn. My name is KiDeuk. I'm a senior fellow in Justice and Safety Division of the Urban Institute. And my previous job, I used to work for a state agency responsible for managing criminal records and sealing of criminal records. So I may come from a slightly different perspective into this research space. And my project focuses on Utah's Clean Slate legislation, which was signed in 2019 and went into effect in 2020. My research project aims to evaluate both the implementation fidelity and the impact of the Clean Slate legislation. For implementation fidelity, which I can talk a little bit more about later, the project initially planned to map out the responsibilities among stakeholders, which agencies should do what, because the records may exist in multiple locations, maintained by multiple agencies. So I was going to map out those responsibilities and track metrics like processing times between eligibility determination and expungement. And for impact evaluation, I will focus on recidivism and, if available, employment and public assistance outcomes. So that's what my project is about.
Thank you all so much. This next question is for Kristin, Alissa, and KiDeuk. Can you each get into some details, talk about the eligibility criteria, forms of relief, and waiting periods in the states that you're working in? How do you see these variations shaping equity and access to relief? Let me start with Kristin.
Thank you, Laura. So, thank you, Laura. So in Pennsylvania, under Pennsylvania's Clean Slate 3.0, the state really has expanded their eligibility criteria because with Clean Slate 3.0, they expanded the convictions eligible for both automated and petition-based sealing, which that now includes some felony convictions. So just to give you a little bit of background and some of the details on the eligibility criteria under Clean Slate 3.0, for those felony convictions, that includes some low-level drug and property-related offenses, but there has to be a 10-year period without any subsequent convictions. Many misdemeanor convictions can undergo record sealing in Pennsylvania, but the waiting period is 7 years, again, without subsequent convictions. Summary convictions can be sealed automatically after 5 years, and non-convictions now can be automatically sealed after 30 days. So one of the studies we've been working on with Clean Slate and focusing on this new legislation takes a closer look at those criteria, recognizing that states really do need to start at some point in terms of setting those criteria for their legislation. And oftentimes, public safety is a primary goal in establishing those criteria. So we wanted to better understand, for example, those waiting periods, 7 years and 10 years for misdemeanors and felonies, and take a closer look at equity. Were there differences by race? And I can get into the details of that, coming up, but we did, the takeaways from this study was really helpful just in terms of, the public safety aspect and recognizing the concern for future convictions. And what we observed looking at both misdemeanor and felony convictions was that future conviction rates steadily decreased after 1 year, with rates of 5% and below after 5 years for both eligible misdemeanor and felony convictions. So we are seeing that, setting those waiting periods, those time frames, really can have an impact on individuals because most people are experiencing success at an earlier point.
I can talk now about California. Thanks, Kristin. That's super interesting. So California started its Clean Slate journey in 2019, focused on marijuana-related convictions after the state legalized marijuana. And then in 2021, the state expanded automatic relief to many arrests that didn't result in a conviction and most misdemeanors. Importantly, when it was first enacted, it was only prospective. So older arrests and convictions were not going to be eligible. And then the latest change was in 2022 with SB 731, which made relief both retrospective and prospective and expanded eligibility criteria. So today, as I understand it, California has the broadest record relief policies in the country. So generally speaking, all arrests are eligible for automatic relief after specified waiting periods, which is 1 year for misdemeanors, 3 years for most felonies. Misdemeanors, non-serious, non-violent, and non-registrable felonies are eligible after specified waiting periods. And then California also added petition-based relief for people that are convicted of serious and violent felonies. So it's really only felonies that require registration under California's sex offender registry laws that are not eligible for petition or automatic relief. The Department of Justice began automatically relieving records in July of 2022. And in the first 2 years, they relieved nearly 12 million records, of which just under 3 million are convictions, which they state is the largest record relief that's been carried out over a short period of time in the United States. I think, Laura talked a little bit about what relief means in the different language, and I think it's important to just, note that relief doesn't erase the record completely. They're still kept by the California Department of Justice. For example, in the administrative records, we can observe a note on the case that says it was relieved. They're visible to police and prosecutors if the person is arrested again. They're disclosed to the State Department of Education, and it doesn't affect prohibitions that California has on firearm ownership. And in terms of equity, one thing I think that's super important about California's laws, and I think a lot of others, is part of it is automating eligibility processes that were already in place. And so as kind of Laura said at the beginning, we know take-up rates are really low. So being able to automate relief, makes it so people don't have to hire an attorney, go through that process. So really just allowing everyone that's eligible to benefit from this. And then kind of lastly, as I talk about the petition-based relief, when we look at kind of demographics of who's in that group, we see that Black Californians are overrepresented among those that are only eligible for a clean slate through petition-based relief. So in the sample we look at, Black Californians comprised about 13% of people with convictions, but they make up about 24% of those who are only eligible through that more onerous petition-based process. So just when we think about equity, as a result, Black Californians are going to be underrepresented among individuals that we think will get a clean slate.
In Utah, their program is for automatic expungement, and there's a specific number of convictions they would expunge, and also different waiting periods for different types of offenses. Right. So for Class A misdemeanor drug possession, it'll be up to 2 convictions that can be expunged, and the waiting period is 7 years. So for 7 years, the individual must not have a conviction. Class B misdemeanors, it's up to 3 convictions, and waiting period is 6 years. Class C misdemeanor and infractions, it's an unlimited number of records that can be expunged, and the waiting period is 5 years. So the waiting period ranges from 5 to 7 years. But hearing from Pennsylvania and California cases, this variation seems pretty narrow, much narrower than 5 years, 10 years in Pennsylvania, and similar story in California. And certain cases are excluded from this, such as DUIs, domestic violence related offenses, sex offenses, and certain weapon-related offenses. That's Utah's program.
Thank you. I'm going to pose a question now to Derek. In your work with the states, what have been the biggest technical or administrative hurdles that you see to automating record clearance? And how have you seen states start to or overcome them? Are there any implementation bright spots worth elevating?
Sure. Yeah. Hurdles. There are many. The hurdles are the easiest thing to talk about. The solutions is where it gets challenging. But yeah, I think I'd like to talk briefly about both technical and administrative hurdles, because I think they're really critically important, especially facing state criminal history repositories and courts when they're tasked with implementing Clean Slate successfully. So At a very high level, some technical hurdles to be mindful of. First and foremost, always front and center, data quality, data completeness. I mentioned in the introduction, one of the areas of interest of our organization here at Search is improving not just criminal history data quality and completeness, but information within our criminal justice system, which stems from criminal history with data quality and completeness. Our systems that house our criminal justice data, and I can say this pretty broadly, speaking nationally, are antiquated. Rather than significant technological advancements and revamping and rewriting a state's entire criminal justice system are few, far, and in between. What happens is we've placed band-aids and stopgap solutions to improve information sharing or add new items within a system, et cetera. So first and foremost, a technical hurdle, data quality, data completeness. Pretty much all of the states that we have worked with have had or have identified some poor quality data, incomplete data, especially, and this is probably obvious on older records. Things like missing identifiers like fingerprints or arrest tracking numbers that are really, really important when it comes to matching records together, say from law enforcement side of things to courts, rather than relying on name-based matching, which can cause some inaccuracies. Having biometric linkages like fingerprints, for example, that allow you to accurately 100% link records together is a challenge because of missing, incomplete, or inaccurate data. I'd like to call out Utah as an example of a solution to this problem. They have worked with another organization called Code for America to develop and improve eligibility algorithms and their data quality components. They've also begun using an entity resolution software that helps better connect records together. And they've seen some pretty significant improvements in that area. Still lots of room for improvement, still lots of work to do in that area. And the hard part or the challenge is, data quality completeness is a pretty broad general term. And there isn't really any consistency in terms of what those data quality issues are by state. Different data quality issues impact different states because of the uniqueness of their system design and software that they use, et cetera. But it's in desperate need of resources and kind of this focused effort to not just look at a system like the courts or the criminal history repository or the DA's office, but to look at everything in its entirety, looking at the criminal justice process within your state. How do we prevent data silos from occurring? How do we improve the flow and therefore completeness and quality of the information that's being shared? And one of the entities to help drive that are criminal justice coordinating councils or committees at the state level that can take a step back and look at an entirety of a criminal justice system objectively. So we're very big proponents of working with those criminal justice coordinating councils as committees. Another technical hurdle, I kind of briefly mentioned this, integration of systems, data sharing. Our criminal justice system, is siloed. We have specific purposes and needs for data. Courts have different reasons and needs of data than criminal history repositories and law enforcement. And being a former government employee from Wisconsin Department of Justice, I can say this pretty accurately. States are so strapped for resources, especially within the criminal justice system, especially within the data and integration field, that they're barely keeping their heads above water. And it's hard to take a step back and look at the criminal justice system in its entirety when you're so focused on completing what you need to complete for your agency, for your court, for your law enforcement agency. It creates challenges to think outside of the box and look at how information can flow and be shared. This impacts every state in some way, shape, or form. Some states, New York, have had some success in developing a robust information sharing system. Michigan is also another state that has developed automated eligibility determination requirements and have developed rules and kind of some data engines that make that connection of data for multiple sources kind of work a little easier. Still a work in progress, but they've made some leaps and bounds above other states in their ability to automate and link records together. And kind of one other large technical hurdle that does impact nearly all of the states is that, again, this goes back to the question previously, the automated eligibility determination, developing specific, accurate, keyword accurate algorithms to determine eligibility based on really complex legal criteria and, like I mentioned, varying data quality and completeness can cause erroneous results. And this is an area where mistakes really can't happen. They have to be accurate. So calling out Pennsylvania and Utah, again, I think have really done a fantastic job at identifying advanced algorithms and business rules that have automated the identification of eligible records. They are continuously reviewing their algorithms, identifying what's working, what's not working to improve accuracy. But from a technical standpoint, I think just broad areas that impact every state: data quality, completeness, integration of systems, and the automation behind eligibility determination. Administrative hurdles, again, just at a really high level, this is probably going to seem obvious based on the previous discussion here, but resource allocation. Implementing automated records clearance does require significant resources. And what that means is funding, staffing, and technology. Those are three things that are absolutely necessary and states need to be aware of and ready to invest in. So we've really identified some federal funding and grants to help states receive some of those resources. From our work at Search, the primary resource that we've been really plugging is a National Criminal History Improvement Program. This is a grant program that is administered by the Bureau of Justice Statistics. Both courts, law enforcement agencies, criminal history repositories are all eligible to apply and provide some, although grant funded, but it's relief for resources and funding, staffing, technology. Hiring staff, contracting staff, making system improvements are key issues that every state needs to be focused on and ready for when implementing Clean Slate. Changes, upgrades, improvements have to be made. And a lot of times it's solving these long-term data quality, data integration issues that states have known about, but now need to address, need to fix with the implementation of Clean Slate. That creates challenges. It also creates improved systems if done successfully. So identifying where states can find resources has been really helpful, and collaborating with courts have been really helpful in determining where to best invest funding and resource allocation. This is a challenge that I think will probably never go away and probably has existed for quite some time, and that is interagency coordination. Sometimes coordinating data sharing projects isn't a technology problem, isn't a resource problem, it can be a person problem sometimes. And historically, because of the different the separation of branches of government between the judicial system especially, have kind of created these focused efforts that create data silos, and getting agencies to work together historically when they haven't. It's a simple problem, but it exists, and it exists nearly everywhere. So we view this as an education problem of really developing educational tools and components that highlight the important role that each person or each entity serves within the criminal justice functions within their state. Everyone plays a role. It's all related, and it all needs to work cohesively together. And once we've spent some time providing some education of why it's important for courts to have, say, a state identification number that allows a biometric link back to the criminal history records from law enforcement, can sometimes seem unimportant to the businesses within courts, for example. When in reality, it is significantly important to the overall criminal justice system. And providing examples of why that matters has really improved some participation and sometimes even eagerness to share data and look at ways to create efficiencies within that process. But that interagency coordination can be troublesome. I do know Delaware is a good example that have established steering committees and stakeholder groups that help facilitate communication and collaboration between agencies. It seems like a simple idea, but it's absolutely effective and really quite brilliant if implemented successfully. And we really recommend states create some sort of steering committee like that. And the other challenge, again, or the other hurdle, I should say, administratively, is the notification and compliance issue. Ensuring that all relevant agencies comply with expungement orders and properly update their records is a key thing. Utah and Delaware have developed some pretty robust notification systems to inform agencies of expungement orders or record sealing orders, and they also provide training and support. Key thing: training and support for that. And in further questions, I'll touch on some bright spots, Laura, from some other states, but I'll pause after that because I know I've been going on about the hurdles, technical and administrative.
No, that's great, and I think it can lead into a question for the rest of our panelists now. How have each of you seen Clean Slate implementation issues impacting research in the field, and how have you seen states working on addressing them?
Laura, I can start this question. I'll be brief. There's been a couple of ways in which our team has observed some challenges related to implementation and then how it's impacted being able to carry out research. So one example which reflects on what Derek just mentioned was quality. So two highlights here. If a state has eligibility criteria or qualifications where, for example, they want to start clearing records for various types of misdemeanors or felonies, but they limit the criteria to particular grades of the severity of those felonies and misdemeanors. So if those types of data elements are missing in any of the automated data systems that are needed for record sealing or expungement, then what happens is individuals who would potentially be eligible for that record sealing would be missed over for the automated process. But that also can impact research because it can limit sample size. It can limit, the findings being generalizable to a whole state, for example. In addition to that, and related to the same challenges, when some areas of a state, perhaps it's the courts, collect specific pieces of information that are necessary for automated record clearing, but other portions of the state do not, or other regions of the state do not, you're going to struggle with the same issues in research in terms of, sample size and generalizability. So we do see that, but many of the states that are doing, clean slate work, are aware of some of these challenges and limitations with their data and working through those processes. Another way that we have seen challenges in the data is for research is the time frame available. Because if one of the goals of the research project is to be able to, take a group of individuals who are eligible for record clearing and there's a waiting period of 7 years or 10 years. If the data time frame that's available for researchers doesn't extend out far enough, you may miss, right, individuals who are either potentially now have records sealed, or what you want to avoid is, of course, identifying individuals who may be eligible, but your sample time frame ends, and they've, ends, for example, in 2020, but it's now 2025 and they've picked up a subsequent conviction. And because the law passed, in 2024, as an example, you'll miss them and you don't want to count them as perhaps having a record sealed. So there are some of these data quality, data time frame issues that really can impact research. And I think to the extent that the field is working very diligently to address these implementation challenges, my hope is that, research and the implementation processes will start to align, so we can better inform and revise policies, right? Revise policies related to waiting periods or eligibility criteria.
I would say, kind of building on what Derek said, and Kristin as well, but, if you expect there to be a change, you would expect there to be a change if the person is aware and if their record actually is accurate. So we've talked a lot about notification. And so, in California, there's no notification. And most people have to pay money to get a background check to check if they have a record. There's some nonprofit groups that run free clinics, but kind of that awareness, there's a lack of awareness, and some of the qualitative research that's around this from our partner Sandra Smith at Harvard has pointed to that as well. And then I think, kind of as Derek pointed to, the relief happens at the state level. It's then communicated down to the courts, and then the local courts are where the private background check companies get their information from. And not our reporting, but research, but reporting by CalMatters and others has kind of indicated that the background check isn't always accurate, whether it's kind of delays in updates, or counties don't have the ability to kind of update records in real time. So kind of that being an issue that we see as well. And then lastly, I will say, just in California, with the petition-based relief, there's really little insight into what's happening. It's not something that's required to be tracked separately by the Judicial Council, for example. So just in terms of equity and understanding who's benefiting from that and who's not, that's kind of a research gap to kind of be able to understand implementation there.
I want to share a bit more broader observation of what's happening in the field generally, right? So just building upon what everybody has shared, especially the challenges that I described. The notification issues, and they are specific to Clean Slate, right? But the data quality issues, data sharing issues, I mean, they're particularly problematic for expungement research, but they are generally applicable to other research involving criminal justice data, right? And for the audience with little experience, exposure to expungement research, let's say I have 10 prior criminal records, and they all have slightly different quality, right? Some records may not have my name spelled right. Some may have identified me as a different sex. And so, but we need to be able to identify all my 10 records and link them to be able to see which ones are eligible for expungement, which ones are not. And it also depends on how long my criminal history goes. So it's really important to be able to link those records. But because of the data quality issues, some records may not be linked. So there's some research on the technical aspects of records linkage. As Derek said earlier, the Code for America came up with a validation study to that. So that's important area of research that we need to pay attention to. And also, there have been numerous data sharing, data standardization initiatives to improve court data infrastructure and availability, reflecting a broader recognition of the need for more accessible, standardized, and high-quality justice system data. Pew started a new initiative, for example, to better understand how court data are shared or used for a variety of everyday struggle, like debt collection, eviction, child guardianship. And the Bureau of Justice Statistics is also wrapping up a national initiative to develop court statistics for the United States. And I'm working with the BJS on that project. And soon we will be able to have inaugural national statistics on court activity in the United States. So there are a lot of things happening in the field that are related to this.
Thank you so much. I'm going to ask one last question to all of our panelists. Looking ahead, what do you see as the most promising and feasible directions for future research to evaluate the impact and equity of clean slate laws, particularly in terms of who is and isn't receiving relief? This question is also getting at how we can leverage multiple methods and data sources, including the available administrative data, considering everything that we've heard already today, in order to study clean slate implementation and impacts. We could start with Derek.
Okay, I'm going to take a more kind of operational tone to this, and I hope that'll spearhead much brighter and better ideas. But I really think that the uniqueness of states' criminal justice systems is just terribly important to understand, and I don't think we do right now nationally. And I think there is a need to research and really dig into and understand from the ground up a state's criminal justice system. And what I mean by that is their process. What happens from the point of arrest to the point of charge, to conviction, to corrections? What does that look like? What systems are impacted? How does or doesn't the data flow? And get a good kind of foundational understanding of how the records are processed, flowed at the state level within the criminal justice system, and start there. Identify the problem. Where do the problems exist, and are they solvable? What would it take to improve the flow of information? We know data exchange, data sharing, integrated justice is an area that states nationally, or that we as a nation ought to invest in. But what does that mean? What does that look like? Where are the problems stemming from? And they're going to be different state by state. There's not going to be a magic bullet that applies to everybody. They're going to be very specific, very, very unique to the state level, and spending some time exploring state by state, which is going to be a lot of work, to really identify the nuts and bolts of how their system is built, how it runs, how it operates, and how data flows through, I think is a really, really important first step. And we do pieces of that. We'll study courts, we'll study criminal history repositories, we'll study law enforcement, we'll study prosecutors. But to tie everything together and really have a robust understanding at a state level, I think is an important starting point. And from there, really developing some target-focused initiatives to improve equity and quality, equality, et cetera, is really what's needed. Otherwise, I fear we're going to be investing in researching problems that we don't quite really understand yet, and we may just keep kind of spinning the wheels and having this conversation 10 years from now. So actually spending the time doing I like to call it, it's fun for me, but it's kind of boring research, but really understanding and providing an educational springboard to say, here is the system, here is what works, here is what doesn't work, here is how the data flows, go after it, I think is really, really important and sometimes missed.
Thank you. How about Alissa?
I would say, we're continually interested in what's happening with outcomes outside the criminal justice system, beyond recidivism. And there's been work in California on, reclassification that suggests that there haven't been big employment effects. So I think kind of building on that and trying to understand, is it related to kind of timing? Is there too long of a lag between relief between the record and when people get relief? So I think kind of building in and understanding that. I think, I think this has come up in other conversations as well, but, thinking about the kind of ban the box research, which, no longer requires people to disclose their criminal record at kind of first interview. Great policy. And then kind of subsequent research actually showed that people, when employers didn't observe a record, they were discriminating based on race. So just kind of understanding kind of some of those potentials for unintended consequences here, I think is just kind of is another kind of area of exploration. And then lastly is just kind of, again, on petition-based relief and these other things that people have talked about, where implementation or kind of data quality issues may impact who's eligible and when they're eligible or not. If to the extent that that's not random, that's correlated with different counties, et cetera. Just kind of trying to understand those gaps as opportunities to kind of improve to then increase who's eligible and the time to eligibility.
Thank you. Let's go to KiDeuk.
Yeah. So generally, a strong empirical research is very limited in this space. So anything we can do to add to that would be great. But what I want to talk a little bit about it is, like, on the other side of this this research spectrum, right? So I think we can do more on some conceptualization. We can do better conceptualization of certain things and more qualitative approach as well. So, I mean, what I mean by that is, public attention focuses a lot on the overrepresentation of minority population in the justice system, with the assumption that, facilitating system exit through measures like expungement will help address these disparities. But it's important to consider who's most likely to have these types of criminal histories and therefore benefit from expungement. Right. Going back to the disparity question earlier, right? Who's likely to benefit most from these policies? We'd expect Clean Slate to have the greatest impact on individuals with the older, low-level convictions. So by definition, older folks would benefit more from expungement than younger folks. And also there's a race-related patterns coming up. So I think we should come up with a better conceptualization of disparity. By design, we may be getting unintended outcome. So that's one thing that I would like to spend more time on.
Thank you so much. And then with just a couple minutes left, Kristin, do you want to add anything?
Sure, I'll be brief. One aspect that we are interested in, just building off the project that we're working on in Pennsylvania, really is to take a closer look at notification, because of the recognition, the understanding that this legal remedy has been available to individuals, even if the process for receiving it is automated. And the second piece is really guided to inform policy and take a closer look at the cutoffs between eligibility criteria, because we can really leverage administrative data and some fairly rigorous analyses to do that, and to have more robust conversations with states and show them using their own data. You took this initial step with your legislation. Here may be the next step that you might want to consider, and here are the benefits of doing so.
Well, thank you so much to all of our panelists. This was a great panel today.
Thanks, Laura.
Thank you for having us. Yes, enjoyed the conversation.
Thank you.
Thank you.
Thanks, everyone.